So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket sheet.
Judge, I feel like you don't want to hear the response, but it's important because
The matter that she's going to another county for, is that a jury trial?
It's not a jury trial to my
This
understanding.
is, she should have came here first.
I understand that, Your Honor. If I could just be heard at.
No, she needs to be here.
I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Courtrooms are meant for justice, but sometimes attorneys take things too far. From outrageous outbursts to blatant disrespect, Judge Boyd has seen it all, and he doesn't hold back. Here are the top 5 craziest attorneys who got put in their place.
The attorneys and the defendants, are you doing this for the YouTube? Because we don't have a record, right? Except for the.
Let's dive in.
All right, I'm going to ask you the same question that I asked everybody else. Has an acknowledgement of discovery been done? Because I don't have it in the court file.
I have signed a few of them at this point.
All right, so has there been any new discovery?
Not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm going to have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'm supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves, too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice in
And
the
say
courts.
that, and it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up
Happening is, I will.
The courtroom is already tense as the attorney strolls in with an attitude that instantly rubs everyone the wrong way. Instead of greeting the court professionally, he starts speaking over the clerk, cutting corners, and acting like the rules don't apply to him. Judge Boyd watches silently at first, studying the attorney's behavior. The judge gives him a chance to correct himself, but the attorney keeps acting dismissive, sighing loudly and making sarcastic comments. By this point, everyone in the room knows something big is coming.
Allow people to go to civil cases, to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your Honor,
All right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right. All right. So I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh, I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first. It is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what? I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes. Here's the thing. You're to be back tomorrow at 9:30. You understand?
Yes.
All right. Thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bexar County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So, for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what ends up
Hey,
happening,
there should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware,
When the hearing officially begins, the attorney goes from rude to outright combative. He interrupts the prosecutor repeatedly, argues with the judge over basic procedures, and refuses to provide direct answers. Judge Boyd tries to steer him back on track, but the attorney keeps challenging the court's authority. Finally, Judge Boyd pauses, leans back, and warns him firmly that this courtroom will not run on his terms. The attorney attempts to talk back again, and that's the moment the judge follows through with strong judicial control.
I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m., and then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I
be
have other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true
You
because all of
understand?
those courts got
All right.
business
Good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today.
Thank you,
Right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
some things
here's
can
your
actually
reset.
occur.
sir.
And they're courts of exactly the same
Sir.
jurisdiction.
Right this way, sir.
Yes. Manuel Rodriguez. All right.
Good morning, Your Honor. Are we on the record?
No, we're not on the record yet.
Could I request that we be on the record? It's a motion for continuance that I'm asking the court to consider.
All right. Are you the attorney on this case?
I am not, Your Honor. And that's part of the basis for the continuance. Lee
Who's the
Cutter,
attorney?
Lee Cutter's the attorney of
And where
record.
is she?
She is on her way to Guadalupe County for another criminal matter, Your Honor, and she's going to be there probably the majority of the morning. And then in the afternoon, she's specially set in front of District Judge Forte.
Okay. Well, she'll need to stop over here in this afternoon.
Um,
Because let me ask you this.
yes,
The matter that she's going to another county for, is that a jury trial?
It's not a jury trial to my
This
understanding.
is, she should have came here first.
I understand that, Your Honor. If I could just be heard at.
No, she needs to be here. I don't know why people are thinking that this is not a criminal district court and that attorneys don't need to come here. This is a jury trial. Where she's going out of county is not a jury trial. This case, I'm sorry, sir, what's your name? Manuel Rodriguez. Thank you. Wow. This case has been set for jury trial. This is the 8th setting. So I don't know why someone would go to another county as opposed to coming to a court where they have a jury trial set. So we will not be going on the record. She will need to be here.
I understand that, Your Honor. And from my understanding of it, there was a jury trial setting in November and December, but those were actually settings for bond motions. So I don't know that they're actually true trial settings, Your Honor.
We're here today for a jury trial.
And I understand. And I did approach the court yesterday with the motion for continuance.
Yeah, and I was not hearing that. I want you to hear me clearly. That attorney is in another county for a case that's not set for jury trial. This is set for jury trial this morning. I don't understand why people don't understand that, one, and I consider myself reasonable, one, that jury trials criminal jury trials take precedence over civil matters. I don't know why people don't understand that. District court matters take precedent over misdemeanor courts. I don't know why attorneys are acting as though they don't understand that. So we will not be going on record. I will not be hearing this motion. She needs to be here. So whenever she comes back from that other county that she's in, I will hear that motion.
I understand.
And whether or not I grant her motion for continuance, I do not know. But what I do know, and she needs to be informed of, is that criminal matters take precedence over civil matters. And when I give people leave to do civil cases beforehand, that's me being kind, but they don't take precedence. And so go forth and tell other attorneys that, one, district court takes precedent over misdemeanors because people seem to have forgotten that, and that district court matters take precedence over civil matters. And that anytime there's a jury trial set, at least in the 187th, and you're going to some other county and that's not a jury trial setting and it's not specially set, they need to be here.
I understand, Your Honor.
All right. Thank you.
Thank you.
All right. So if y'all put that on the record that you're waiving his presence. All righty. Let me find it. And are you ready to proceed?
Sort of. Defense did file a request. I did respond to that request. I'm sure there's a copy of it. I do have a copy if you like.
Yes.
And then today I was handed an affidavit that I reviewed. My response doesn't address the affidavit, so I guess I can just.
Okay, where's the affidavit? Because I don't have it.
I gave a copy to the court. That should be with the court's file.
It's a century.
Judge Boyd stops the entire proceeding and addresses the attorney directly. His tone shifts from patient to ice-cold authority. He lays out every instance where the attorney has violated decorum, from interrupting, to refusing to follow procedure, to showing blatant disrespect. He explains that being licensed to practice law does not give someone the right to act above the court. The attorney tries to defend himself, but quickly realizes that every excuse is shut down by the judge's precise and controlled responses. The courtroom stays completely silent.